A federal court has once again determined that the laws preventing people from owning machine guns violate the Second Amendment. However, Attorney General Bondi and the Trump administration are continuing to argue against gun rights in this important constitutional case. Let me explain what's happening in this significant legal battle. Before diving into the details, I want a favor from you guys that if you found this video helpful and want to stay updated on important Second Amendment cases like this one, make sure to hit that like button and subscribe to the channel. Your support helps us keep bringing you the latest developments on gun rights and constitutional law. As I mentioned at the start, this video covers a crucial Second Amendment case about machine guns that's currently before the Fifth Circuit Court of Appeals. In the U.S. v. Brown case, the Trump administration continues making arguments against gun rights and is trying to get the Fifth Circuit to skip reviewing this case altogether. The United States government recently submitted a brief to the Fifth Circuit, continuing their position that machine guns don't receive Second Amendment protection and requesting that the lower court's ruling be overturned. They also filed an additional notice pointing to a recent victory they secured in the 10th Circuit Court of Appeals, which also dealt with machine gun bans. This other case is called U.S. v. Morgan, and the Morgan case was actually the first district court ruling to strike down machine gun bans. The Brown decision we're discussing relied significantly on that earlier Morgan ruling. Now the Trump DOJ is using their 10th Circuit victory to try influencing the upcoming 5th Circuit decision and possible oral arguments. They're also attempting to prevent the 5th Circuit from even hearing arguments in this case. In the Brown challenge currently before the 5th Circuit, the lower court judge initially explained that Section 922 makes it a crime to possess a machine gun unless that machine gun was legally owned before the date this law went into effect. As Judge Brooms described in U.S. v. Morgan, the law criminalizes simply having these weapons regardless of how someone uses them. He explained further that if someone buys such a weapon and locks it in a basement gun safe for 20 years without ever touching it, that person is just as guilty of violating 922 as someone who brings the same weapon out in public and displays it aggressively in the streets. He continued by saying that all prior appellate court decisions had become obsolete. Under the new framework created by Bruin, the government has to prove that its preferred firearms restrictions, which in this case means the law criminalizing simple machine gun possession, align with our nation's historical tradition of firearms regulation. This represents a significant burden, he noted. The historical justifications that the federal government presented in this case for the machine gun possession charges and prosecution of Mr. Brown included things like the Statute of Northampton, which relates to riding and going armed in a way that causes fear and terror among good citizens, but the judge rejected this as invalid historical support for Mr. Brown's conviction. The judge also noted that the record indicates more than 740,000 machine guns are legally possessed throughout the United States as of 2021. He stated that 740,000 is no small number and that the government offers no argument or explanation for how such a large number of firearms isn't somehow in common use for lawful purposes. To challenge the number of machine guns presented in this case and the entire common use argument, the federal government and the Trump administration relied only on a previous Fifth Circuit case called Hollis. However, that case is now invalid because of Bruin, and the number of machine guns presented in that earlier Hollis case only accounted for approximately 175,000 machine guns. But now under Bruin and the clear counting of at least 740,000 machine guns, the argument is that Hollis doesn't stand as binding precedent and is essentially overridden by what happened in Bruin. Based on that reasoning, the judge agreed with Mr. Brown's as-applied challenge and granted his motion to dismiss the case on Second Amendment grounds. The U.S. government responded by appealing that decision to the Fifth Circuit. Now, one of the major problems with this case is that the Trump DOJ keeps making anti-Second Amendment arguments in this challenge and in other challenges involving machine gun possession laws. In the federal government's recent brief, they argue that lower court decisions involving machine guns were clearly wrong and should be reversed. They argued that machine guns aren't typically owned by law-abiding citizens for lawful purposes. Instead, they claim these weapons are uniformly restricted, highly lethal, and well-suited for criminal purposes. This really just represents a standard anti-gun argument coming from the Trump DOJ, which is disappointing to see from the Trump DOJ and AG Bondi's office as they continue pushing these anti-gun positions. They also argue that Bruin's analysis didn't override what the Fifth Circuit said previously in that Hollis case. They claimed that nothing in Bruin unequivocally overrules or overrides the Fifth Circuit's prior precedent. They claimed that even though Bruin corrected the type of Second Amendment analysis that should be performed in these cases, it didn't directly address machine guns or that Fifth Circuit precedent in Hollis, and therefore it still remains valid. In this case, the plaintiff recently submitted their brief arguing that the lower court performed the analysis correctly and that at minimum, the Fifth Circuit should hear oral arguments in this case, despite the Trump administration arguing that the Fifth Circuit should avoid this entirely, that they shouldn't hear oral arguments and should instead just reverse and send this case back down. But things just became somewhat more complicated in this challenge because recently the 10th Circuit ruled on the Morgan case, which again involved machine gun challenges. In that decision, the court determined that Morgan failed at the very first step of the Supreme Court's Bruin test by proving that the machine guns he possessed were arms in common use today for lawful purposes like self-defense. The judges in the 10th Circuit emphasized that although handguns and other widely owned firearms receive protection, machine guns such as the ones owned and possessed by Mr. Morgan, like a Glock switch, are not commonly used by law-abiding citizens for self-defense. They determined that instead, history and precedent demonstrate that these types of machine guns are overwhelmingly linked to unlawful uses. They believe these weapons are used too often in crimes and not used for civilian defense, and therefore they don't have Second Amendment protections. The Trump DOJ recently submitted that 10th Circuit ruling in this Brown appealed to the Fifth Circuit, saying that the Fifth Circuit should essentially just follow exactly what the 10th Circuit said. So this case continues moving forward and the administration keeps arguing against machine gun possession and maintains that these weapons are not protected arms under the Second Amendment. Even worse, they're arguing that the Fifth Circuit should simply not hear this case at all. They should not hold oral arguments in this case, but should instead rule right now based on the papers, rule based on what the 10th Circuit said in that other Morgan case, and reverse what the lower court said here in this Brown decision. So it's unfortunate to see that the Trump DOJ continues pushing these anti-Second Amendment arguments, these anti-gun arguments, and now they're trying to use a decision they obtained in the 10th Circuit as additional support for why this Fifth Circuit appeal should just be rejected and this case should be reversed and sent back down. And that machine guns don't have any Second Amendment protections at all. So now we're going to wait and see what happens. But unfortunately, as I said, the Trump DOJ continues making these anti-gun arguments on this issue of machine gun possession. They're still making these arguments in these machine gun possession cases. So now we'll have to wait and see how the Fifth Circuit handles this. Are they going to simply align themselves with what the 10th Circuit said in that other Morgan case? Or are they going to at least hold oral arguments in this case, hear the plaintiff out, and consider and weigh these issues on their own? So this is a huge case, a huge decision, and a very important appeal in the Fifth Circuit dealing with machine gun laws. As we get more information and as this develops further, I'll keep you guys updated. If you enjoyed this video and want to support the channel, one of the best ways to do that is to subscribe to the channel. But as always, thank you so much for all of your support. And never forget, this nation was built by rights and reloads, and this nation will be maintained by rights and reloads.